SJC-11712, Commonwealth v. Damian Didas.
Good morning, Ms. Stevens.
Good morning, Your Honors. May it please the Court. Assistant District Attorney Bethany Stevens from Middlesex, appearing on behalf of the Commonwealth. There is no basis to apply the changes to the elements of a trafficking offense retroactively to offenses that were committed prior to the effective date of August 2nd, 2012. Here, the offense was committed on May 3rd, 2011, well over a year prior to the changes affected by the 2012 crime bill on August 2nd. Consistent with the normal rules of statutory construction, there would only be a basis to find retroactive application if there was a manifest intent by the legislature to apply retroactively. The only manifest intent in this legislation is in Section 48. There it reads, and that's on page 7 of the Commonwealth's brief, that the changes to the sentences would apply to already incarcerated individuals at the time of the act. To find the benefit of a change in the elements to apply to pending cases through Section 48 would also require finding that change effective to already incarcerated individuals, and the Act does not provide for that. Okay, the only way for you to provide for the changes to the elements would be to allow through a motion for a new trial or a new trial, as this Court recognized in Thompson with respect to the school zone changes.
Except that in 48, it does mention the sections that we are talking about here.
That's right, Your Honor. And the trafficking changes were amended in Section 21 of the bill, which is in the Commonwealth statutory addendum. Right. And what Section 21 did was it rewrote entirely subsections B1 and B2 to include both the changes in the weight as well as the sentence, yes, so that the only way to provide the benefit of the change to the sentence is to reference Section 21. That doesn't necessarily mean that everything included in Section 1 is to apply, because the rest of Section 48 provides that these retroactive changes are going to be brought out through terms of probation, makes them eligible for probation, parole, work release. It doesn't provide for a new trial. And the only way to provide this change in the elements to already convicted defendants would be to have a new trial. They wouldn't be able to have their conviction, a B2 conviction, amended down to a B1 conviction without a fact finding of what the actual trafficking weight was.
So we're talking about all of the folks that would have been convicted prior to this, right?
That's correct, Your Honor. It's Section...
Yeah, they'd have to essentially, if they wanted to take advantage to the retroactivity that the defendant claims is there, they would have to file a motion for a new trial, and there would have to be a trial on the actual amount they possessed.
That's correct, Your Honor. That's absolutely correct.
You're suggesting that the legislature clearly didn't intend that.
That's correct. So this is not a Galvin situation where there's a benefit being conferred to already incarcerated individuals that this pending class is not receiving that same benefit.
But if you are a defendant and you take the what's alleged by the Commonwealth, let's say this defendant had been convicted.
Yes.
Okay. And I appreciate the fact that the DOC doesn't interpret that way, but I don't put that to one side. So somebody's convicted. The weight was 28.4 grams. It's now changed categories. And that would mean, I take it, that you may be eligible for parole earlier, right? In addition to the change in the sentence, the top number, right?
If you reduce the charge to a lesser included offense that has a lower sentence, yes, you could get there, but we already are getting there because all the changes to the sentences have been reduced. This defendant, at the time he committed his offense, was
would it be a double reduction?
Correct, Your Honor. That's right.
So why would it necessarily be the case that that isn't what was intended? I'm not talking about this defendant. I'm talking about somebody who actually is specifically covered by Section 48. That is, they've been convicted.
Because the language of Section 48 provides that it specifically refers to the things that they can obtain through applying these changes, and that would be that they are now eligible for probation, parole, work release, or release shall be eligible for probation, work release, and deductions in sentence for good conduct. It is not saying they shall be eligible for a new trial, and I'm saying that that would be the only way to obtain a change in the element of the offense.
So help me here. He was arrested on May 3rd of 2011.
That's correct.
If he had been gone to trial on, say, July 1st, 2012, before the new law,
That's right.
and been convicted, he would have had a 5-year mandatory.
Correct, correct.
But he would then be eligible for parole under the new law.
That's right, at 3 years.
At, you say at 3 years or 3.5?
3.5, I'm sorry, 3.5.
At 3.5, but given the weight, why would he not be eligible after 2 years?
Right.
Because there is no fact finding as to the specific weight. When a jury finds a defendant guilty, they find him guilty of trafficking in over 18 grams. There's no specific finding of what the actual amount is, whether it's 23, 24, 18.5.
Okay, so why couldn't he go to the parole board and waive the lab report and say, it says here that the weight is 28.4, therefore I should be receiving the benefit of the new law, and I should be eligible for release in 2 years because that's what I'm entitled to?
Because the parole board is governed by the conviction for which he is stand. He's been convicted of subsection B2. And for the parole board then to alter his conviction and say, no, now you're subject to a B1 conviction and actually change the conviction goes far beyond what Section 48 allows. I would suggest that the parole board just doesn't have that authority to redefine what the crime is of which the defendant was convicted. It does not provide a mechanism that way. And I would suggest that the legislature's intent was to reduce the minimum mandatory sentences in addition to reforming the criminal law with respect to the weights. The reduction in sentences is being provided to all the defendants. The reform of the criminal law with respect to the weights should, consistent with all other statutory construction, just apply prospectively, recognizing that when the legislature wants to reform the criminal law, a line has to be drawn somewhere. It makes sense that you do it by the date of the offense. Here, the date of the offense is unless you're going to try to find a way to apply it to the already incarcerated individuals, and it's the Commonwealth's position that the parole board does not have the authority to do that below what the actual conviction is. That if you ended up just applying it to the pending cases, you're having defendants who committed the offense on the same date, and arguably some that even committed after the date of this offense, who were final before.
I guess I'm still confused though, because if you take somebody who, where you're not changing the element, but the parole, but the crime of which he was convicted had a sentence, a mandatory minimum of 5, and now it has a lesser mandatory minimum.
Yes.
And same weight, but lesser mandatory minimum, and therefore an earlier parole eligibility date, and that's what's getting applied now, even though he was convicted before. Isn't the parole board doing the same thing?
Well, I would say no, Your Honor, that the parole board is just affecting the legislation through Section 48 that says B2 offenses, those that are convicted of subsection B2, who previously were in on a 5-year minimum mandatory, these subsection B2 convictions are now eligible at 3.5. They just automatically receive the lowered minimum mandatory sentence. That's all that it does.
So the legislature's intent was, we want persons already incarcerated to get the benefit of the lower mandatory minimums, but not the benefit of the changes in mandatory minimum based on weight.
That's right, Your Honor. And I think the reasoning would be is that it would, the only way that you'd be able to do that is to have a new trial and have a fact finding of what that new weight is to see, do they actually fall to the lesser included or not?
Even though it's been charged with a specific weight.
Well, it hasn't been charged with a specific weight. The indictment reads trafficking over 18.
Right.
We present to the grand jury what the what the certificate, the drug analysis is. In this case, the defendant had also reweighed the drugs as well. We don't have information as to what that reweight came into, but there can be a dispute about what the actual weight is that the jury is going to have to find.
I thought it was trafficking over 28.
I'm sorry, it was trafficking over 18, over 28. Excuse me, thank you, Your Honor.
So he was just charged with trafficking between 28 and 100?
That's right. The indictment's in the Commonwealth's appendix, and it's just trafficking over 28 grams in violation of subsection B2.
But if the concern that the legislature would not want a new trial is correct, in this case, there would, of course, be no need for a new trial. There was no trial. The judge was saying going forward in this trial, he gets the benefit of it. So should we then say, okay, you're right, if the person had been tried, he's stuck with it, but if he has not yet been tried, he gets the benefit of it?
So what I'm saying, Your Honor, is that when looking at legislation and determining whether it should have retroactive application, we look at the rules of statutory construction, and retroactive application will only be there if there's a manifest intent by the legislature. Here, that'd be Section 48. So if you don't read it in Section 48, we don't have a manifest intent of the legislature, and then we would look to whether the exception, as explained in Bradley, that it would be otherwise repugnant to the overall context of the statute, requires it to be applied to retroactively.
Well, but you could say that the manifest intent is to lower all these things, and actually for the people that are incarcerated, yes, we're going to limit the lowering to what is said in 48. But it's clear that the manifest intent is to lower things. So if you have somebody like this defendant who has not yet been tried, it is consistent with that manifest intent that he gets the benefit of the change of location of where 28.4 that is on the certificate that is claimed by the Commonwealth falls under.
And I would respectfully disagree with Your Honor. I would suggest that there needs to be a manifest intent. Otherwise, to just say, we know that there's an overall intent for the legislature to want to reduce mandatory minimums. That is being achieved here because the defendant here at the time of his offense was liable for 5 years minimum mandatory. He is receiving the lowered minimum mandatory to the 3 years. To say that to further affect the intent, I think the best case on that is Watts, is the Commonwealth versus Watts case, where in the juvenile situation, the court recognized that the legislature sought to reform the criminal justice system under some very compelling...
That had a lot of legislative history that is very different from this.
Arguably, Your Honor, but I think it just recognizes the point that the legislature, when they want to reform the criminal justice system, that those reforms are going to be applying prospectively, and that to get around, to retroactively apply it, there needs to be something more than just, it's possible that they might have wanted to give everybody the best benefit possible. I would also suggest that while this defendant, his case is still pending, there's other defendants who committed the offense on the same date and after the same date who have resolved their cases. They're not in the same position. The defendant here filed this motion in September of 2012, about a month after the effective date of the crime bill. It appears from the record that no action was taken. There was a hearing at the same time. The defendant filed a motion to reweigh the drugs. It was not until 2013, after this court issued the Bradley decision, that it was then supplemented with this memorandum. So the cases before September of 2013, courts and judges in the Commonwealth have not been applying the changes to these elements, to the trafficking offense. We have been applying the lowered mandatory minimum sentences pursuant to Galvin. And so to single this defendant out just because his case has taken longer than some of the other cases may have, I think would essentially, would be an incorrect reading of our rules of statutory application of construction, and arguably is unfair. I think that in this sense...
Doesn't the unfairness go away if we say that if you can show the parole board that it was only 28.4 grams, that you should be entitled to the benefit of the lower weight as well?
I guess so. I guess I would have a hard time seeing how that would be actually applied in terms of, does the Commonwealth have an opportunity for a hearing, or, is this a litigation before the parole board for them to make a factual determination about what the exact weight was? We don't have a jury. I'm not aware of any of the cases where we've had a special verdict slipped with respect to what the exact weight was. So there just was no fact-finding with respect to this. We're talking here the changes in the elements of the crime.
But it's not, it's not that hard to measure weight when there's a lab report which would say it. This is about the easiest fact-finding that's available.
I would just say that, that would then create a exception to our statutory construction to be, in drug cases, we're going to have this special rule that applies because the element is not as, is potentially more ascertainable than some other elements. I think just like any other crime, when we change the elements of the crime, the rules of statutory construction is that the date offense controls, and the court should continue to be consistent with those rules. If there's no other questions, thank you.
Thank you.
Good morning, Your Honors. A.J. Blank for Mr. Didas. The recalibrated and reconfigured trafficking levels as set forth in the 2012 crime bill do apply to those with pending cases, as Mr. Didas.
I would say they apply to anyone who had cases pending, even though they've now subsequently been convicted and sentenced under the B2, for example, in this case. They now can, file motions for new trials to have their offenses reclassified?
Well, acknowledging that there's an administrative hurdle to impose the legislative intent under Section 48, I think the legislature's intent under Section 48 is clear. They have specifically included Sections 21 and 22, which covers cocaine trafficking, and Sections 25, which covers heroin trafficking. They also included Sections 20 and 24, which do not have any term of years in them. There's nothing to do with a sentence year at first glance. All they do is Section 20 amends the first paragraph of trafficking in cocaine and says trafficking is now going to be at the 18-gram level and higher.
So if I understand what you say the parole that right now, somebody who's been convicted of 28.4 grams and charged and before the effective date of this law would now be eligible for parole in 2 years. Is that right?
Yes.
Well, they would have to prove. They would have to have some evidentiary hearing, presumably. No,
not necessarily. I think because you would say the basically you look at where that conviction is now over 18 grams, right?
Right.
And so you put it into somewhere else.
Well, now it's what, 36 to 100?
36 to 100.
So
yes.
So there would be people who maybe claimed, well, I actually had 35. We didn't really go into the details about that. Maybe. I mean, you'd have to have an evidentiary hearing as to where they would lie on the new range, and the parole board would be having that hearing. That seems odd.
The evidence as to weight in a drug case is very straightforward. It goes to the lab, it's weighed, and a certificate is generated. That certificate, prior to holdings 10 years ago, was allowed in as evidence of the weight and the fact that it was drugs. Now, at a plea colloquy, the judge has to satisfy him or herself that there's an adequate factual basis for the plea, and the Commonwealth generally holds up the certificate and says we would have proven at trial that the drugs weighed this much, the defendant's admitting to that during a plea. Now, during a trial, same thing, but through lab personnel. So, as with the school
But there's been no finding. The only finding from the jury is that it's over 28 grams.
Right.
That's the finding, and so there would have to be some sort of hearing before the parole board as to whether or not, yes, over 28, but actually below 36, therefore I should be reclassified to an offense with a lower element.
Or providing the drug certification.
Do we do that anywhere? Do we do that in any other circumstance? Have the parole board sort of conduct that kind of charge reduction hearing and fact-finding?
I don't know of any.
And what if the defendant had already gotten the benefit of one reduction in trafficking levels? What if he had originally been charged with possession of 100 grams or more, and then through plea negotiations got reduced to 29 to 100? And what if there are 3 certificates that add up to 50 grams, and they're all like 18. There's 3 of them times 18. Don't we still have to have a hearing to make sure that the parole board gets all 3 of those certificates?
Yes, and I think there would have to be some sort of procedure set up for that with those hearings to make sure that the weight is being properly shown and stated by the defendant. But, you know, even though there is this hurdle, the intent of the legislature was clear in Section 48. They included the section dealing with trafficking weights and the sentences. And I think that shows that the two are...
How many cases are we talking about? Any idea?
No.
Over what period of time did this likely happen?
Well, it would have to be
A window. Yeah.
Well, I think, wouldn't it have to be, oh, I don't know, actually, no, I don't.
Well, if
There aren't that many cases, are there?
I wouldn't think so, because if you look at what was affected by the weights, it was the first 2 staircases of the trafficking statutes. So it took 3 years at this first level down to 2, and 5 years down to 3.5. Now, the Galvin decision, and the DOC was implementing it prior to the Galvin decision, the Galvin decision came down in 2013, the law changed in 2012, so we already have this time where people with pending cases were getting the benefits.
Of the years off the sentence.
Of the years off the
Not of the change
sentence.
of the element, as Ms. Stevenson said.
Right, but we're not dealing with too many because of the timing of it all, I would think.
Let's go to 48, because, you know, 48 says any person incarcerated on the effective date of this act is eligible for probation, parole, work release, or release, and deductions in sentence under sections 21-12 to 29. It's really not talking about a reclassification of the offense, and we're talking about people who were incarcerated on that date, getting a chance to get released earlier, right?
Yes, but...
Because your reading would say, well, anyone incarcerated on that date should be able to go back in and get their indictment amended or reduced or changed.
Well, the legislature included sections which fall between 12 and 29, sections 20 and 24, that do not affect, at first glance, the sentence.
Well, first of all, your client was not incarcerated on the effective date.
He was not.
Okay.
His case is still pending.
Right. And what is it your suggested that if you were incarcerated on that date, you in fact were incarcerated, therefore this would apply to you, that you would then be eligible to get your conviction reduced from a B2 to a B1?
Yes, because...
and how would you do that?
I do not know.
As opposed to just getting eligible for earlier release, or... You don't know how to do that. I know, it's a problem.
It is a problem. And, you know, I think just because it's a problem doesn't mean the legislature did not intend it.
Well,
I think you could probably...
I don't see where it says that they intend... They're really talking about sort of reduction in the amount of time that someone who's already incarcerated for these offenses would get or be eligible to get. Doesn't it really talk about reducing the level of their criminality, changing the elements of the offenses under which they were convicted?
Well, I think a couple points on that. Again, the legislature included Section 20 and 24. Section 24 rewrote the first paragraph of the trafficking and cocaine statute and said now it's trafficking if it's over 18, not over 14. That's all that Section 20 did, is amend that. Why include that if they did not intend to give people sentenced that benefit? What they've done, seems to me, they included that because now they're saying between 14 and 18, parole eligible now. because he didn't face a mandatory minimum. That's the only reason to include sections 20 and 24, which changed when the trafficking statute becomes applicable. It's the only explanation for it. And so that's their intent. Now, the trafficking statutes, they're basically an enhancement of possession with intent to distribute or distribution. The only thing that enhances the possession with intent to distribute is the weight of the drugs. And that doesn't require any additional criminal wrongdoing by the defendant. It doesn't require even knowledge that the drugs weigh a certain amount. All it requires is proving the weight of the drugs is this amount. You prove it's 18.5, this mandatory minimum sentence kicks in. It's an enhancement, much like the school zone was an enhancement for those distribution offenses around a school. All you do is in a school zone is take out your tape measure. All you do in a trafficking case is take out your gram scale. You weigh the drugs, you get your sentence. That's what trafficking is. And
so my guess here is, as of the effective date of this legislation, there actually might have been a lot of people incarcerated for drug trafficking in the amounts here, and a fair number of cases pending. And you would say in all of those cases, there needs to be a reduction not only in the sentence, but in the level of their criminality, an element, so literally anyone was sentenced at the time could now come in and say, I need to have my indictment redone because I wasn't convicted of B2, really was only convicted of B1. There might be collateral consequences to that for sentencing in future offense. I mean, that's a mess and a half.
It may be, but the legislature included it. There's no getting around the fact that the legislature included
well, it talks
sections
about parole
21.
and pardons. It talks about those parole, and work release and things like that.
Yes.
It doesn't talk about reducing the level of the criminality.
They talk about reducing sentences, and the sentence and the weight are not distinct. They're inextricably intertwined. The weight determines the sentence. They go hand in hand.
Well, let me just make me clear. Take my example where the person is convicted of this same crime before the change in law. He would have gotten a 5-year sentence. You're saying that he would be eligible for parole at 2 years? Or are you saying his sentence is reduced to 2 years? Just as it's purely the eligibility for parole.
It is, yes.
So he'd still have a 5-year sentence. That would not change.
Right. DOC would make him eligible for parole at 2 years now.
And his conviction is still B2 versus B1?
It would be the same conviction.
I would guess.
The conviction would not change. It
Right.
would be a 5-year conviction, but he
Under
could be
B2.
Right.
under B2, but he could be released in 2 years.
Yes.
But the problem, of course, is that if your client is convicted, he would not be eligible for Section 48 because he was not incarcerated on the effective date.
Correct.
So if you're right about what happened before, then he would be worse off because he would not be eligible for parole until 3.5 years.
Well, I think that if the person sentenced is eligible for parole at 2, under your example, that according to Galvin...
But it says any person incarcerated on the effective date of this act. Your client was not incarcerated on the effective date of this act, so he would not be the beneficiary of Section 48.
Well, this court held in Galvin, though, that Section 48 applies to those with pending cases at the time of the effective date of the act.
So he would be sentenced according to B1 even though convicted of B2? Is that what you're saying?
He would be sentenced according to B1 now, because his case is pending.
No, I understand that, but so he would be, the Commonwealth would have to prove the old B2, are you saying, right? Because that's what he was charged with. In other words, that he had 28, that the 28.4 really was 28.4, but if found guilty, his sentence would be what's available to somebody if charged now, would be charged and convicted under B1?
Well, I think that with pending cases, it's easier than that. You just take it and make it a B1. It's what it is now. You have the drug certification. There's no question about the weight, really. When you enter the plea, the judge finds a factual basis for that plea. Commonwealth has to say what the weight is. I think that with pending cases, there really is no obstacle to providing the relief intended by the legislature.
All right, thank you.
Thank you.